The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video, we'll be discussing the limitation for probate claims in Illinois. We'll talk about claims deadlines applicable to a decedent's estate in Illinois and what stipulations may affect the claim deadline. We'll also talk about if it's possible to override the statute of limitations on a claim and what happens if a claimant files a claim but the representative does not allow the claim or disallows the claim. So when a person dies and their estate enters into probate, creditors will have the opportunity to file a claim against the estate. Anyone who has an action against the decedent may file a claim against the estate, including claims for things like breach of contract, collection of debt, or any other types of liabilities. So generally, the statute of limitations for probate claims in Illinois is going to be 2 years following the death of the person in question. After those 2 years, no matter the reason, the claim will be barred. However, the representative of the estate can shorten that 2-year window by following the correct steps and making their best efforts to notify the creditors. Also, the type of creditor will affect the deadline too. So for example, in the case of unknown creditors, if the decedent didn't keep proper records of his or her finances or something like that, the representative may not know to whom the decedent owed debt, or the creditors may not be reasonably ascertainable. So the representative could hope that no unknown creditors come forward for the 2-year period, but he or she could also shorten the claim time frame to 6 months by publishing a claims notice on the decedent's estate in the proper channels. The 6-month allowance would begin on the date of the first publication. So in the situation of a known or reasonably ascertainable creditor, after the creditor receives an actual claims notice, the creditor has 6 months from the date of the first publication of the claims notice, or 3 months from the date of the delivery or mailing of a written claim notice. And if a creditor is known or reasonably ascertainable, but the representative of the estate elects for whatever reason to not send a written claims notice or publish a general claims notice through the appropriate channel, the creditor will not be held to the 3 to 6 month period mentioned previously. Instead, the creditor will have the general statutory limitation of 2 years to file a claim. So, can the statute of limitation on a probate claim be overwritten? Generally, no. The State of Illinois Probate Act sets the claim limit at 2 years, and there are plenty of examples of the courts upholding this provision. So let's say, for example, in a case where a woman's attorney mailed a letter threatening to file a claim against the deceased husband's earnings during their marriage within the 2-year mark of his death, the court ruled that the mailed letter was not sufficient as a claim. The woman later filed a claim through the proper channels, but since it was outside the 2-year mark, even with a prenuptial agreement signed before the marriage, the courts barred the claim based on the 2-year statute of limitations. Another case involving modifying the decedent's child support obligation was barred because it was filed 2.5 years after the decedent's death. The point is, even if there is already a relationship, an attempt made, or an existing legal agreement between the parties, if the claim is not filed within the appropriate 2-year time frame, it's going to get denied. The one deviation from this statute is if the decedent's estate has liability insurance. In this case, the 2-year limit would not apply to actions to establish liability of the decedent. And then lastly, in the case of a claimant filing a claim with the representative and not with the court, the representative can decide to disallow the claim. The representative would have to file a notice of disallowance with the court and then mail or deliver that notice to the claimant. This notice should state the date that the claimant must file the claim with the court, which cannot be less than 2 months from the delivery of the disallowance notice. As always, thanks for tuning in.
Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.